once again, this is Dr. Olu Asekun here. Welcome to our weekly podcast. Thank you for joining. If you are yet to join, please join right now. If you are already online, please call your colleagues, your family members, and let everyone join us for this interesting podcast. Yeah, this is Dr. Olu Asekun again. This podcast is every Wednesday, Central Standard Time. That is 12 p.m. Dallas time. That is 1 p.m. Eastern, 10 a.m. Pacific. And I think currently it's 6 p.m. Nigerian time. Okay, welcome to our podcast. Today, we are continuing with the living and working in the United States series. I believe we started this series before our trip to Nigeria. We didn't do it last week because we wanted to clarify the President Biden's executive action. But today, we are continuing with the series, living and working in the United States. I remember at the last episode on this topic, the last series, living and working in the US, we stopped about at when somebody eventually obtained the visa. So today we are continuing. When you obtain visa, what next? That is where we are starting today. After obtaining visa, what next? Of course, if you plan to work or live in the United States, the first thing is to obtain visa. We have discussed all that. Now, having secured visa, what next? So today, the first thing I want to point out is that visa does not guarantee admission into the United States. In fact, visa is only a document that is directed at the airlines. It's a document that is directed at the airlines so that airlines are not penalized for bringing illegal people into the United States. So once you have a visa, of course, you get your ticket and then you show the visa to the airline before they will allow you to board so that they are not liable. So the moment the airline or the airplane step down in the United States at the airport, everybody comes down, everybody, including US citizens, permanent residents, visa holders, everybody comes out of the plane. Technically, you are still in your home country at that point. So you get to the border point, which is the CBP officers. Usually, the line between the CBP and the guests, the foreigners coming into the US, that line separates two countries technically. So when you are standing across from the CBP officers, technically you are still standing in your home country. You have not been admitted into the United States. Although your airplane has touched down, you have come out of the plane, technically you are still in your home country. So until you approach the CBP officer, who will collect your passport, take your picture, collect your fingerprint, and then determine whether or not to admit you. Now, again, at that point, technically, you are still in your home country. When the CBP officer admits you, it is from that point that you enter the United States. So if we are going to be talking about working on living in the United States, until you pass the CBP point, you are not in the United States yet. I hope this point is very clear because it is very, very important. Your visa does not guarantee admission. Your visa only ensures that the airplane or the airline will allow you to board. So the ticket you paid for, you paid the airline. You didn't pay American government. So as soon as the plane touches the ground here in the US, the airline's job is done, but you are still not in the US. You have not been admitted. When you approach the CBP officer and the CBP officer admits you, it is only from that point that you are admitted into the United States. Now, the CBP officer, just like the consular officers, they have a lot of discretionary authority. They could deny your admission into the United States despite your visa. I'm sure you must have heard of people who were turned back at the port of entry. The CBP officers have those discretionary powers. Now, they could exercise this power if they have a suspicion. One thing I want you to understand and note is that the CBP officers at the port of entry, they have access to the consular application that you did. They have access to the information that you provided to them at the embassy when you apply for visa. They have access to a copy of your application for visa. So whatever information you provided to the embassy when you are applying for visa, the CBP officers have access to that information. And I'm going to be discussing this because some of the reasons why people can be turned back or people can be denied admission, it is also because the CBP officers, they have access to information that you provided to them at the embassy when you apply for visa. While I continue this explanation, if you have questions, keep sending them in, but I'm going to keep explaining. So, as I said, if, for example, you told the consular officer at the embassy when you are applying for visa that you are coming to attend a graduation in California, that was the information you provided. Maybe they ask you, how long are you going to stay? Oh, I'm just going to be there for 2 weeks. I'm only attending the graduation. After the graduation, maybe I do 1 or 2 shopping, then I return to my home country. Maybe that is the information you provided to them at the port of entry. Now, not realizing that the CBP officer have access to that kind of information, maybe the officer asks you at the port of entry, oh, why are you here? Oh, I'm here to visit my cousin. Oh, I'm here to visit my friend. That's already problematic because you told the officer at the embassy that you are coming for a graduation in California. Now, when maybe your airplane landed in New York, the CBP officer is looking at your ticket and realize that, or maybe they even ask you, where is your final destination? And you told them, oh, my final destination is New York, or my final destination is Dallas, or my final destination is Maryland. Meanwhile, you already told the consular officers that you are going to California for a graduation. So that's already problematic right there. So the CBP officer may have reasonable suspicion that no, you didn't come here for graduation as claimed during the interview. Of course, the officer is not going to tell you that he or she knows what you told them at the interview. It's not going to do that. But they are looking at that information and they are going to encourage you, they are going to urge you to keep lying. They already know you are lying because you told the CBP, you told the consular officers that you are going to California. Now they are asking you, why are you here? And you are telling them that you are here to visit your cousin in Maryland or to visit your friend in Dallas. That is completely contrary to what you told them at the port of entry. So that can generate suspicion. That can lead to you being denied admission. There are several reasons that someone could be denied admission. That is one of them. Another thing that could lead to denial at the port of entry, Okay, maybe the CBP officer is asking you, oh, welcome to the United States. How long do you plan to stay? And you told them, oh, I'm staying 1 month. Then the officer is asking you, how much money do you have with you? And then maybe you say, oh, I have $500. That is again going to be problematic. If you are going to stay, if you are going to spend 1 month in the United States and you have only $500, except you show evidence that you have already paid for your accommodation, your hotel, your transportation or anything, $500 is not going to be enough, because if you don't already have accommodation, $500 may not even provide you accommodation for 1 month in the United States. But assuming that you already have your accommodation, maybe you are staying with a friend, then you can tell the officer, oh, I'm staying with my friend, I don't have to pay for hotel. The officer may ask you, what's your friend's name? What's your friend's number? While you are right there, the officer can put a call through to your friend. So if your friend is not expecting you, that may be problematic again. Even if your friend is expecting you, but if you didn't discuss the arrangement of staying with your friend, with him, if the officer asks your friend, oh, are you expecting anyone? Anyone? No, I'm not expecting anybody. That is problematic. Or the officer is asking your friend, are you expecting anyone? Oh, yes, I'm expecting my friend. Oh, where is he coming from? Oh, he's coming from Africa, or he's coming from Germany, or he's coming from wherever. And then the officer, okay, is he going to stay with you? Oh, no, 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 he's not staying with me. He's staying at hotel. Meanwhile, you have already told the officer that you are staying with your friend. Again, that is problematic. Those are the samples of the kind of things that can lead to someone being denied admission. Again, let me give you another example, because all these things I'm telling you based on experience. Let me give you another example. I know someone who has been here previously, a religious music minister. He has been here previously. He performed at a couple of churches. I mean, this was a voluntary performance, not that he was hired or anything. This was voluntary performance, or what we call gratuitous performance. Okay, as a minister, maybe you attended a church. Oh, this person knows how to play the instrument, and then during church service, you perform the music, you play the music and all of that. But at the end of the service, maybe the church decided to give you honorarium. Now, it is illegal for you to work in the United States with a visiting visa. If you come to the United States with a tourist visa, or what a lot of people call visiting visa, visiting visa does not authorize you to work in the United States. So the moment you are getting paid, that becomes a violation of your status. Now, out of ignorance, if they ask you about it and you say, oh, yeah, they just gave me honorarium at the end of my performance, that becomes problematic. So you could be denied admission because of that, because that constitutes a violation of your status. Unfortunately, I've seen a lot of people, because officers are trained not to tell you what is wrong with your application. They are trained not to tell you about any adverse findings they have, or any adverse information they have about you. So they are going to be talking to you casually. You will think that you are having a normal conversation. Meanwhile, they are recording all these things against you. Oh, we see that the last time you were here for about 3 months. Oh, what were you doing for those 3 months? Oh, did you visit any church during those 3 months? Oh, did you perform there? Oh, yes. Oh, at the end of your performance, were you given honorarium? Oh, I know that you didn't work. I know this was a gratuitous service, but did they give you honorarium? And you admit to all of these things. They are not going to interview. and then that is when they will tell you that, sorry, we are denying you admission because the last time you came, you violated your status. At that stage, you start wondering, what did I do wrong? Oh, what did I do? Is there a way to fight it? My brother, my sister, no, there is no way to fight it. Admission into the United States is discretionary. It is discretionary. There is no way to fight it. So it is better to have all this program. The reason we do this program is to prevent avoidable errors. Is to prevent errors. I call this avoidable errors because what you don't know does not hurt you. But if you know, you will be more careful and not fall victim. There are a lot of people who did things innocently without any intention of violating their status, without any intention of violating the law. But unfortunately, some of these things carry what we call in law strict liability offense. Whether you intend it or not, if they can show that you have violated your status, you are out of status. Your intent may not matter. So it is important to understand all these things so that you know how to be more careful and how to really enter the United States without getting into trouble. Now, still talking about examples, there are other examples why someone could be denied admission. Maybe as a family, you have a visa. Maybe your spouse previously entered the United States before you do. And maybe they gave your spouse 6 months at the port of entry. Now, your spouse has been here for 7 or 8 months. He or she didn't depart. Then subsequently, you came in here and then they look at the record. Oh, the last time you apply for visa, we see that you apply as a family. We also see that your spouse entered the United States last year and there is no record that he or she has departed and you are just coming. Oh, there is a presumption at that moment that you do not want to go back. There is a presumption of immigrant intent at that moment, and that could lead to you being denied admission into the United States. It could also, that is this, a situation that could also prevent you from getting a visa approved in the first place. But we have moved past the visa stage. We are talking about admissions today. So that you have a visa does not guarantee your admission into the United States. And I'm giving series of examples of the kind of things that can prevent you from being admitted into the United States despite your visa. Again, there are so many examples. The few that I've mentioned, they are not exclusive. There are so many examples. Those are the only ones that can come into my head right now. Generally, another thing that the officer, the CBP officer can look at, they can look at your travel record. I've seen this also in the past. I've seen clients who are affected by this. Somebody left, in this particular example, somebody left Nigeria, went to the UK, from the UK came to the United States, spent about 2 months in the United States, left the US, went to Dubai, spent about 2 weeks in Dubai, and flew from Dubai back to the US. Guess what? That client was denied admission at the port of entry. What was the reason? The CBP officer said that, look, in the last 3 months, you have not even returned to your home country. You have been flying around. To the officer, that is an evidence that you didn't intend to return to your country. A lot of people do travel, but normally if you travel, you are supposed to go back home. But in this case, you have traveled to Europe, you traveled to the US, you traveled to Dubai. Instead of going home, you came back to the US the second time. What is wrong about going back home? So at that moment, the officer concluded that the client did not intend to return to her home country. So the client was denied admission. Before I go further, let me say, obtaining visa, getting admitted into the US, these are steps that are 100% discretionary. So if you are denied admission, calling a lawyer is not going to help, because there is nothing the lawyer can file. There is nothing the lawyer can do. If you are denied admission, you are denied admission. Until you enter into the US, you do not enjoy all the legal rights, the right to an attorney, the right to seek a relief. All those things, you do not have those benefits until you are admitted. The only exception is somebody who is applying for asylum. If you have a fear of returning to your home country, at the port of entry, if you are denied admission, you can express that fear. Officer, I cannot go back home, because if I do, I'm going to be armed, or I'm going to be killed. I'm going to be applying for asylum. You can do that. The only problem with that is that you should be prepared to be detained, because in such a situation, they are not going to grant you admission. No, they are going to detain you and then bring an asylum officer who will conduct what we call credible fear interview. This may not be the same day. You may be in detention for up to a week or two, or even up to 1 month before the credible fear interview is conducted. Now, if they conducted the credible fear interview and the officer found that your story is credible, meaning that on the face of it, they can see that if they return you to your home country, your life will be in danger. In such a situation, the officer may do one of three things. Number one, they will issue a letter to you called credible fear letter. So that letter will confirm that they found your story credible. Now, finding your story credible does not mean that they granted you asylum, because you have not even applied for asylum. Now, if you are found credible, they will now give you the opportunity to apply for asylum. Remember, from the date you show up at the port of entry, you have up to 1 year to submit application for asylum. So they will give you the opportunity to submit an application for asylum. Then the officer will decide whether they are going to parole you into the US, or whether they are going to give you a bond, or whether you are going to be detained. So there are three options before the officer. If they find your case credible, they may decide to parole you into the country. If they parole you, that has a lot of advantages. If you are paroled into the US, that has a lot of advantages, because even with the parole document itself, you can apply for employment authorization. Excuse me. If you are paroled, that will be extremely beneficial. One, if you are paroled, that can give you the ability to apply for employment authorization as a parolee. Two, if you are paroled, that can also give you the opportunity to apply for a change of status or adjustment of status if you are paroled. On the other hand, if you are granted bond, that means that they will release you on bond. Either you post a bond, or they release you to a US citizen, whichever the case. But even after that, you have up to 1 year from the initial date of entry to file your asylum application at the court. Remember, because you declare asylum at the port of entry, this is not going to be an asylum that you are going to file with USCIS. This is not an affirmative asylum. It is only going to be a defensive asylum, which means they will place you in removal proceedings. Even though you have been found credible, they will still issue a document called notice to appear. So that document will tell you that you have been found inadmissible to the United States and that you have been charged to appear before an immigration judge. Usually the NTA will explain that you are not a citizen of the United States, you are a citizen of XYZ country, you entered the United States or attempted to enter the United States on or so date at so port of entry. And then the NTA will add that you did not have the requisite immigrant visa to enter the United States, and then on the basis of the foregoing, you are subject to removal. So NTA will list those allegations for you, and then they will put you in removal proceedings. Now, if you are granted bond, you still have an obligation to submit your asylum application within 1 year of entry, because if you don't, the ability to apply for asylum will be limited, because asylum requires that you file your application within 1 year. So if you did not file it, you may be statutorily ineligible for asylum, even despite being found credible at the credible fair interview at the port of entry. So it is important to understand all of these things so that when you are planning to come to the United States, you don't make avoidable errors or avoidable mistakes. I see by now that I have some questions, so I think I will start answering the question and then continue explaining along. The first question received via text message. This information you are providing is very valuable. I had the impression that once a visa is granted, I was going to be admitted for sure. No, visa does not guarantee your admission. It does not guarantee your admission. The next question: if I have criminal history on my country, could admission to the United States be denied? Yes, it could be denied if they have information about your criminal history. Remember that these officers at the port of entry, they are not magicians. So they may not even know that you have criminal history. However, let me say this: American government, American security, the Department of Homeland Security is one of the most sophisticated in the world, if not the most sophisticated. So, the fact that you have criminal history in your home country does not mean that they may not know. I can tell you authoritatively that American government have access to a lot of fingerprinting from different countries in the world. Even if you have never come to the US before, even if you have never lived in the US before, they have sophisticated technology. So if your criminal history in your home country, if for one reason or the other it is linked to your fingerprinting, I can assure you that at that port of entry, when you run your fingerprinting, they will know that you have criminal history. And of course, if they do know, depending on the nature of the crime, you could be denied admission. I mean, if the crime is a minor offense like traffic offense and all of that, it may not be an issue. They may just ask you what happened. But the truth of the matter is that in this modern era, it is very likely that even the embassy, the US embassy, will probably know about your criminal history and deny you visa. But if you, let's say you have been issued 5-year visa, and then a year after you had the visa, you now committed a crime. Yes, at that stage, you may have escaped the embassy, but you will still be faced with challenges at the port of entry. But again, the officers are not magicians. Sometimes you may escape it, they may not see it, and sometimes they may see it. They may not see it because they are not particularly looking for you. Remember, every port of entry in the United States, at any point in time, there are always thousands of people waiting in line to enter the US, including US citizens, including permanent residents. So it's not as if they are looking for you specifically. So sometimes you may have criminal record in your own country and escape it. But then, even if you do, if you enter here and then apply for a benefit, whether you declare it or not, they may find out eventually that you have the criminal history once they start running your background check. The next question: if I'm admitted to the US with a visiting visa and I begin working, what will happen? Well, you know that this is a series. We are talking about coming to live and work in the United States series. So we started from how do you even come to the US? We discussed that. We discussed the visa process. Today, we are discussing the admission process. We are still going to discuss how people can change their status, how they can work legally and all of that. But we don't want to go into that today because this is a process. We don't want anybody to jump any of the process, because if you don't understand the process, what you don't know can hurt you. So we are explaining it step after step. That is why we call it series. So today we are dealing with the admission process. We are still going to get to working stage. So let's limit it to the admission process for now. So that is what we are dealing with right now. So the next question: I would like to attend school in the US. What will I have to do to be admitted for this purpose? Again, this person is also talking about what you do after you have been admitted. Like I said, for the purpose of organization, I want us to follow this trend. We have spoken about how to prepare. We have spoken about obtaining the visa. We are talking about getting admitted today. And next week, we are going to now talk about after admission. What do you do? But today, we are talking about admission. The reason we are devoting today's topic on admission is because we see so many cases, we hear so many calls all the time about people being denied admission, about people coming. Sometimes people will call me, oh, I have my sister, the immigration, they just denied it admission, they didn't allow him, we need a lawyer, we need a lawyer. There is nothing any lawyer can do. It is important that you understand the process so that you don't waste your money for nothing, because these are discretionary issues, and that is why we are discussing this topic one after the other. So today, let us concentrate on admission. What are your options? We have discussed it. The fact that you have a visa does not guarantee your admission. The fact that the airplane brought you into the United States does not guarantee your admission. The fact that you are already here does not mean you will be admitted. So what are your options? What are those things that can prevent you from being admitted? Do you have history? Have you been here before? And maybe you in fact, recently this week that we are in, I still receive a call from someone who had been here multiple times. But guess what? The last time the person was here, she had a baby here, went back home, then came again, landed in the US through on her way to Canada. So she went to Canada. Now, when she finished her assignment in Canada, she wanted to spend about a week in the US, and her flight, her return ticket back to her home country was actually from the US. But guess what? From Canada coming back to the US, she was denied admission because, again, the CBP officer who interviewed her at the port of entry was asking her question about the previous time she was here, how she had a baby. She said yes, she had a baby, but she paid for everything. She brought out the invoice, the receipt and everything to show that yes, she had a baby, but she paid for all the expenses. She didn't get any government benefit and everything. But guess what? The officer denied her admission into the US. These are the things that are happening, and that is why we are discussing this topic today. Please, I want you to send questions relating to admission. That is what we want to discuss today. Next week, we will discuss about change of status after you have been admitted into the US. Kim, please help me note it next week. Change of status after being admitted into the US. We will discuss that next week. But today, we are discussing admission because it's a serious problem. It is what we see all the time. We receive phone calls all the time for help, but unfortunately, we are helpless. So it is important for people to understand what can lead to all this denial of admission. There is a saying that prevention is better than cure. So since I've been practicing, I am yet to see someone who was denied admission and any lawyer or even anybody was able to stop from being deported. Of course, with the exception of those who apply for asylum. Yes, if you apply for asylum and they conduct credible fair interview, yes, you may end up entering the US. But other than that exception, if you are denied admission, there is nothing you can do. There is nothing any lawyer can do. Not even the president. President Biden cannot do anything about it. They will just sympathize with you, nothing more. There is nothing. No congressman can help you. No governor can help you. There is nothing. No lawyer can help because that is the law. It is the law that gave these officers a discretionary authority. And the court have ruled several times that when a discretionary authority is given by the Congress, the court cannot tell them how to use their discretion. The moment a court is able to tell an officer, oh, this is how you should use your authority, this is how you should use your power, then it is no longer discretionary, and that will not be contrary to the powers given by the Congress. So the court has said that all the time. So it is important to understand all these things so that whatever can be avoided should be avoided. Whatever is preventable should be prevented. So that is why we are discussing these topics today. The next question. I would like to attend school. Oh, I think that's the one I just finished answering. Okay. We will deal with that next week when we get to change of status stage. Question received via text message. In the case my H-1B visa was granted and I decide to come into the US through the Mexican border, can they still ask me questions about the job I'm supposed to do? Oh yes. Oh yes. Like I said, when somebody is carrying a non-immigrant visa, all non-immigrant visas, no exception, every single non-immigrant visas are discretionary. It doesn't matter whether you have an employer petition for you. I've represented a lot of organizations before where we filed petitions and petitions were approved. But when the applicant get to the embassy to get the visa, they denied it. We have seen H-1B visas that were approved in the US, H-1B petitions that were approved in the US, and when the applicant went to the embassy to apply for the H-1B visa, it was denied. We have seen where H-1B was approved, H-1B visa was granted, and when the applicant attempted to enter the US, he was denied admission. So all these things are discretionary. Yes, they can pick up a phone and call the employer and verify the employer. Even for student visa, they can pick up a phone and call the school. They can pick up a phone and call the organization. And if there is a discrepancy between the information you are providing and the information that the the employer is providing, yes, they could deny you admission. In fact, I've seen a client before who is a Canadian citizen. You know that with Canadian citizen, they can work in the United States under what is called NAFTA, North American Free Trade Agreement. Canadian citizens can apply for what is called TN visa and use it to work in the US for US employers. I've seen a situation where someone with a Canadian citizen, a white Caucasian with a Canadian passport, applied for TN visa and was approved, but was denied admission at the port of entry because the CBP officer called the employer and asked some questions about the employment. The employer provided information that is direct opposite of what the applicant was providing. They denied the admission. So all these things is possible. Admission could be denied despite you having the H1B visa. The visa is, like I said, is still H1B is still a non-immigrant visa, and all non-immigrant visas are 100% discretionary. Next question. Question received via text message. If when coming in, I provide an address of a family member who is not currently legal in the country, could this be any consequence to him? No, it doesn't. However, it may be a consequence to you. Now, let me say this. If you provide an address to a CBP officer, most of the time, they just verify that the address exists and the person you are going to lives there. However, where there is a suspicion, a CBP officer can go further by trying to verify the status of the person you are visiting. If the officer decided to do that and now determine that the person you are visiting is not legal, yes, that can factor into the officer's decision, because if your friend is not legal, there is a presumption that when you go into, you too will decide not to return. Excuse me. So it may not affect your friend, but it may affect you. It may affect you from being admitted. So it is always good to provide the address of someone who is legal. Let me also say this. CBP office, either at the airport or in any city in the United States, is a place you don't want to visit if you are not legal. Let me repeat it. CBP office, either at the US airport, any airport, or any CBP office in the United States, is a place you don't want to visit if you are not legal. The first thing CBP officers do is to verify the legal status of anyone they are talking to, even including lawyers. They are going to verify your legal status before you talk to them. So if you are not legal, I advise you, don't go near them. It is a recipe for disaster if you are not legal. So providing information to someone to use if you are not legal is actually where I come from. It's like we call it sending invitation letter to the devil. So you don't want to send invitation to the devil. So that is all I will say about this question. The next question, question received via text message. If I come in with a visiting visa and I work and get a W-2, but I don't file taxes with it, Can the USCIS find out about it? Yes, they can find out about it, but we are going to hold to next week once we start discussing a change of status. But the simple answer is yes, they can find out about it. But again, as I said, today we are discussing admission because this is a series and we don't want to break the series. We have discussed how to prepare to come and live and work in the US. We have discussed how to obtain a visa. So this series today, we are discussing admission. And by next week, by God's grace, we will be discussing now that you have entered the US, how do you change your status? So those are the things we are. So today we are discussing admission into the US because, like I said, there are so many issues with admission, with getting admitted, that we don't want to leave it. We don't want to leave any stone unturned. So we want people to send in questions about being admitted into the US. I've explained it from the beginning and I'm repeating it again. The fact that you have a visa does not guarantee your admission. Any non-immigrant visa, it doesn't matter the category, does not guarantee your admission. So the fact that you have now obtained a visa, does that mean you are sure of entering the US? The answer is no. You can still be denied because with your visa, when you get to the port of entry, when you are facing the CBP officer, you are actually submitting an application for admission. The only difference with normal application is that you don't pay for it at that point, but you are actually applying when everybody is lining up at that CBP line. After you come out of the airplane, you are technically standing in your home country applying for admission into the United States. And like any application, any application at all, applications can be approved and applications can be denied. And in this case, because it is a discretionary application, it may be approved, it may be denied. So the next question, there's a comment here that says there is no image. I don't. Yeah, that was from before. Okay. So the next question, when I was a minor, I crossed the border using someone else's identity and I was able to cross successfully. Could I be denied a visiting visa for this reason? Well, this information is not complete. Number one, when this person entered successfully, did he or she go back to his or her home country? That is one question that I need answered. In addition, when you say, could you be denied a visit when you crossing at the time, were you fingerprinted? Was there a biometric? Is there a paper trail that connects you with that name? Because if you come in as Olu Asekun at the port of entry and you are admitted in today's America, before you were admitted, they will have taken your fingerprinting, they will have taken your picture. Even all of this will show Olu Asekun, but you are stuck with that name because your fingerprinting is already in the record. But guess what? The day the real Olu Asekun shows up too, there's going to be problem because now there will be two fingerprinting, and science has shown that no two people have the same fingerprinting. In fact, let me say this. I've seen US citizenship being revoked because of something like this. I've seen US citizenship being revoked because they found two different fingerprints for the same person. So it is not possible for one person to have two different fingerprints. Definitely, it is not possible scientifically. So at a point, it's going to be a problem. However, assuming, like I said, this question is not 100% clear. Assuming that this person did not provide fingerprinting, assuming that there is no paper trail to show that this person has previously been to the US, you may still be able to get visiting visa, because again, when we say that visiting visa is discretionary, this discretion is actually both ways. Is a two-way discretion. Personally, in my office here, I have seen people who are statutorily not eligible for visa and they were granted visa. Again, it is discretion. So you can't go back to question the consular officer. Oh, why did you give this person visa? No. Once the visa is granted, it's granted. I have seen someone who was deported here in the US. He was deported at the United States government expenses. This person was returned to her own country in Africa. I'm not going to mention the country. It's not Nigeria. So this person was returned to her own country. Within a month after she was deported, this person went to the US embassy and applied for visiting visa. Guess what? She was granted. She was granted. So she bought a ticket and returned to the US. When I saw her in my office, I was like, it's not possible. How did you do it? She said she just applied and they gave you visa. She said, yes. Can I see the visa? She showed it to me. I was stunned. So when we are talking about discretionary issue, it is both ways. So it is not only in the negative, but it is also in the positive. So if the officer decides to use his discretion to give you visa, same way, nobody can question it. You come in, you get in, that's it. If you are supposed to be returned at the port of entry, but the officer decides to look at you and say, you know what, I'm going to admit you, that's it. There's nothing. Nobody can change that decision. Nobody can challenge that decision. Once you are admitted, you are admitted. So when we are talking about discretionary authority, I want you to understand that it is positive and it is negative. It can be used both ways. It can be used to deny someone admission. It can also be used to grant someone who is otherwise not eligible admission. So the discretionary authorities can be used both ways. The next question. If I take a large amount of items with the intent to sell them in the US and I have a visiting visa, can I get in trouble? Well, this is a very tricky question because there is not a yes or no answer on it. When we are talking about visiting visa, there are two types of visiting visa, especially tourist visa. There are two types. We have what is called B1, B2. B1 is visitor for business. B2 is visitor for pleasure. Now, if you have a B1 visa, if you come into the US with your goods with the intent of meeting maybe a distributor, with the intent, maybe you are coming with a African merchandise and your intent was to discuss with an African store who will be serving maybe as your distributor, they cannot deny you admission because of that, and you have not violated any law by doing that. So if you come in, you supply the distributor and then you go back to your home country, you have not violated any law, because visiting visa do have the opportunity for business, and that is why B1 visa is for visitor for business. Visitor for business, you can come in and discuss business, you can come in and transact business, you can come in to sign a contract, you can come in to establish a company, you can come in to have a memorandum of understanding with an existing US business. You can come in to have a partnership deal. You can come in to discuss business. It is not illegal. That is why it is called visitor for business. But it is not the same thing for B2, which is what majority of people always get. B2 simply means visitor for pleasure. Pleasure means you are here for vacation. You are here for to attend a ceremony, maybe a wedding ceremony, maybe to go on a cruise that will depart or end in the United States. So those are the kind of things B2 visa does, which is different from B1 visa. So if you have B1 visa, you can actually come in and discuss business. You can come in and transact business. The next question. My fiancé visa application has been approved. Could I be denied admission into the US? It is unlikely, but the answer is not a definitive yes. The reason is this. Number one, fiancé visa is also a non-immigrant visa. Number two, if you have a fiancé visa, there is a presumption that you have a fiancé who is a US citizen. Now, because your fiancé is a US citizen, it is unlikely that your application will be that your admission will be denied. However, the reason I say it is not absolute is that your application can still be denied if the CBP officer have any reason to suspect that the claimed relationship does not exist. It can still be an issue. Let me give you an example of someone I attended to earlier today. This person is from one of the African countries, not Nigeria. This person came to the US. No, a US citizen. This person met a US citizen. I think they met online or something. The US citizen traveled to Africa. They fell in love. They started dating. Eventually, they got married. The US citizen came back here, filed a petition on the person's behalf. The petition was approved. The US citizen, this person, the beneficiary, applied for an immigrant visa and everything, and then was granted. Now, before entry into the US, the US citizen discovered that this person has another wife in Africa, that this person has a family in Africa, wife and children. What did this person do? The US citizen went to court here and filed an annulment of the marriage. Now, this person, the applicant, was not aware of the annulment. So when this person was now attempting to enter the US, the CBP officer, for some reason, found out about the annulment. And guess what? They denied admission. They denied admission. Because you cannot build something on nothing. Everything that was filed, everything that was approved, everything that was done was based on the marriage to the US citizen. And now that marriage has been annulled. Annulment means that it was as if the marriage never existed. It was as if the marriage never happened. So, on what basis will this person be admitted? There was no basis. The carpet has been swept. Is it below him, or how do I say? So it can happen. It can happen. You cannot build something on nothing. So it can happen. But like I said, it is unlikely. Generally, 99% of anyone who gets a fiancé visa will be admitted. But yes, there is still room for that 1% if they found something wrong with the claimed relationship. The next question. Can I change my type of visa once I'm in front of the officers for admission? Example, I received F1 visa but decided I don't want to go to school and I want to visit instead. Is that possible? No, that is not possible. In fact, that is a recipe for disaster. Once you bring it up, I assure you 100% they will deny you admission. That is a recipe for disaster. You cannot do that. If you plan to change your status, get admitted first. When you come in, you now apply for a change of status. But telling the CBP officer that the purpose for which you obtain the visa, that is not the purpose for which you are trying to enter the US, they are going to deny you admission. So that is a mistake you don't want to make. The next question. If I am not granted admission into the US after flying into the US, what will happen to me? You'll be returned to your home country. Of course, the US government will pay for your flight. They will pay for it, but you'll be returned. The only exception is if you decide to apply for asylum. In my country, we say kawosoke. If you raise your hand, I want to apply for asylum. That's the only exception. But even then, that still does not guarantee you admission, because you will only be admitted if the asylum officer, because CBP officers are not asylum officers. CBP officers are different from asylum officers. So the CBP officer is going to detain you, and then they will contact an asylum officer who will now come to the detention and conduct a credible, fair interview. If the officer found you credible, that is when they will now parole you into the US. Otherwise, you'll be returned to your home country. The next question. If I am granted an immigrant visa and given an I-551 stamp, could I still be denied admission into the US? You cannot get an I-551 stamp until after admission. So if you are talking about getting I-551 stamp, that means you have been admitted. So that's not a question that is possible. If you are given an immigrant visa, your visa only authorizes you, as I've explained, the airline to bring you to the US. So when you get to the port of entry, when you present your immigrant visa, that is when the CBP officer will give you that I-551 stamp. That I-551 stamp is an evidence of permanent residence. So from that moment, you have already been admitted. So you can't be denied after you have been admitted. The next question. I was granted a visa, but I had someone else prepare the information for me. I don't even know what it says. From what you are saying, I don't think that I should travel with this visa. Part 2, could the visa still get me into trouble later, even if I don't use it? What will happen if I do decide to use it, but they find out the information is fraudulent? Well, based on this information that you provide, my advice to you is to contact a lawyer in the US and do what is called a FOIA. FOIA means that they will apply for a copy of your record from the US Embassy. And when you have that, you will be able to see the information provided on your behalf. Now, when you see the information, it is from that moment that you will decide whether you still want to use the visa or not. If the information is the type of information that you can defend, then you can come in and use the visa. On the other hand, you can also come in with the visa if you, it depends on the situation. If you are able to find an immigrant way of adjusting status here, you may come up clean and tell them about the fraudulent information and then apply for a waiver of there's a waiver of ground of inadmissibility called misrepresentation. And I believe that we have a podcast, we have a topic on waiver of misrepresentation. So you might want to go and look at that. But if you don't have a basis for a waiver, if you declare, if you come out clean, you may end up not being able to come to the US ever. So it is a tricky situation. But try to find out the basis of the content of your application. Usually, if you know the content of the application, just come in with the right information. After you are inside, it is much easier to come out clean and apply for visa than when you are outside. When you are outside, a lot of factors will work against you. But when you are already inside, some factors will work in your favor. You can come out clean and then plead for leniency, plead for mercy, apply for a waiver, and then you will still be good. So it's not the end of the world. There may still be solutions to it. But before you go on, try to find out what information you have, because it will not make sense for you to have in your application that you are going for a wedding, and then you come to the port of entry, you are telling them you are here for 1 week vacation. It will be contradictory. So it is always important to be consistent. Consistency is the key, and that is the key word, consistency. Even if you are lying, be consistent with your life. But the moment you have contradiction, is going to bring lot and lot and lot of problems. Okay, I think that is the last question for now. And I also see that we are even beyond 1 p.m. Okay, is there any question that you already received that I don't have? Because I always promise to answer every question before we round up. Okay, so in the absence of any other questions, we'll be rounding up today. But like I said, this is a series coming to live and work in the United States. We have discussed how to prepare for a visa, obtaining visa. We have now discussed entry. Then from next week, by God's grace, we will go into changing status from one visa to another, or adjusting status from a non-permanent resident to a permanent resident status. I hope to see you again next week. Remember, the only thing you can do to show appreciation for this free message that we provide every week is to let other people benefit. Of what purpose is it if you are the only one benefiting from this information? Freely we are giving you the information. Please let others also benefit. Invite your friends, family, your co-workers, let them benefit. You never know where this information may be useful. You may even be a US citizen believing that, oh, everything they are discussing does not concern me. What about your brother? What about your sister? What about your nephew? Somebody may be in this situation, and then you suddenly remember, oh, I listened to one podcast from Dr. Asekun. This may be helpful. For that reason, please invite your friends to join us, and we hope to see you again next week, 12 p.m. Central Standard Time, 1 p.m. Eastern Time, 10 a.m. Pacific, and currently 6 p.m. Nigerian time. Hope to see you next week. God bless you.